Hello and welcome to our webinar. I hope all you're doing well. My name is Dora Leonidou and I'm a Junior Legal Specialist of Eltoma Corporate Services. The today webinar will focus on the liability of persons who serve as directors in a company duly incorporated under the laws of the Republic of Cyprus. The webinar will firstly examine the definition of the company director. It will then start analyzing the laws under which a company director, including a nominee director, has a liability, and will go further to analyze the extent of such liability as well as the consequences of breach of director's obligations. The webinar will conclude that the nominee director must be very careful during his directorship, and he shall also take preventive measures to avoid any potential liability arising out of his directorship. So let's start with the definition of the company director. Director is any person who occupies the position of director by whatever name called. There is not any specific definition in law describing who can be considered as a nominee director. Therefore, a nominee director is nothing less than a director bearing all director's duties and liabilities. Many laws impose specific duties and liabilities on the directors, including companies law, criminal law, social insurance law, AntiMoney Laundering laws, directives and regulations, VAT law, and assessment and collection of taxes law. Now, we'll go a little bit deeper to analyze the existing legislation and the legal grounds under which a company director may be prosecuted. According to the Companies Act, any provision in any contract with a company exempting any officer or identifying him against any liability which would otherwise attach to him in respect of any negligent act or default, breach of duty or breach of trust of which he may be guilty in relation to the company shall be void. So any provision exempting the director against any liability is not valid and shall be void. Also, a company director may be found liable by the Inland Revenue or Customs and Excise with regards to tax-related issues. The Inland Revenue or Customs and Excise may personally prosecute the company directors who are involved in any taxation offences or related financial matters. So the important point here that you need to focus is that the director may be prosecuted personally. It's not the company that will be prosecuted, it's the director. You also need to understand that the line between legitimate tax avoidance and tax evasion is very thin, and thus both the companies and their directors must be very careful when entering into any transaction or concealing any matter from the tax authorities. Companies and their directors have a legal obligation to provide the tax authorities with accurate and not misleading information. So, both the companies and their directors must avoid providing the tax authorities with any false, inaccurate, or misleading information. Breach of such obligation may lead to civil penalties and interest charges. However, the Inland Revenue as well as Cyprus Customs and Excise have the power for serious breaches and for serious offences to bring a criminal proceeding against the company director as an individual. So not only against the company itself, they are entitled to bring a criminal proceeding against the company director who is involved in tax evasion, either personally or through their companies. Now, under the current legislation, there is no offense of tax evasion as such. So there is no specific article in criminal code or in tax legislation or in any other law giving us a definition of tax evasion or describing what constitutes a tax evasion. There is no provision stating that specific actions or specific behavior may be considered as tax evasion. So, although there is no specific definition of tax evasion and there is no specific article providing that the tax evasion is an offense, the company director still may be prosecuted personally for the evasion of tax by deceitful means. So, the evasion of tax by deceitful means represents fraudulent act. The three possible channels of prosecution will include cheating the public revenue, false accounting, and conspiracy to defraud. Now, although the Inland Revenue and Customs Exist have the power to prosecute the company director, in the majority of the cases, they will give the opportunity to the individual, to the company director, to give an explanation, to come clean, provided that full disclosure is made. Hence, a criminal prosecution against the company director is unusual, and the Inland Revenue will rely mostly upon civil penalties, such as administrative fines. Kindly note that indeed criminal prosecution is rare, but keep in mind that it may happen. So the company director still has to be very, very careful. It is also worth mentioning that the Inland Revenue is not reluctant to bring a criminal proceeding against a professional advisor who helps a client to evade tax. In such instances, the Inland Revenue will find the professional advisor liable for a conspiracy-related charge if the professional advisor takes any action or gives any advice to any client in order for him to evade tax or to avoid compliance with his tax obligations under the law. So, when we're talking about professional advisors, the Inland Revenue is extremely strict. And the reason is that the professional advisor has full knowledge of the law and he does know what constitutes a tax evasion. In this stage, we need to examine further the assessment and the assessment and collection of taxes law. Under the tax legislation, directors are responsible for submitting tax returns and take all required actions to assess and submit the company's taxes. In case the company is found guilty for the offense of fraudulent or deliberately submitting inaccurate statements or inaccurate returns or inaccurate accounts, or even if the company is found guilty for non-payment or for delaying payment of taxes, the director can also be found criminal liable for such an offense. Of course, administrative fines may be imposed on the director if the director fails to submit tax returns or omit or refuse to provide information. Now, based on the Memorandum of Understanding between the Republic of Cyprus and the Troika, the House of Representatives voted for specific amendments to the assessment and collection of taxes law, and specifically to the section 51A. With the amendments made to this section, the following apply, and please pay attention to that point. For taxes that are withheld at source, for example, for income tax, for special contribution, for special contribution for defense, one can be charged as guilty in case of delays in paying such a tax. If the offense of non-payment or delay in payment is committed by a legal person, by the company, then responsible for committing the offense, in addition to the legal person, may also be the managing director of the company, the members of the board of directors, as well as any other officer who exercises financial management duties for the legal person or any other person that is allegedly acting in such capacity. So, any of the persons referred to above can be charged as guilty in case of omission or delay in the payment of such a tax without having to prove to the court that the offender acted in fraudulent manner. So the tax authorities can bring an action against the company director for omission or delay in payment of tax without having to prove that the company director acted in a fraudulent manner. In case of conviction, in other words, if one will be found liable for delay in paying such a tax, he is subject to penalties and imprisonment as follows. And please note that the applicable prison sentence and fines have been increased after the amendments to the law. For legal persons, for companies, the fine starts from 1,700 euros up to 5,000. For individuals, for the company directors, the fine is the same as the companies, so it starts from 1,700 to 5,000, or to imprisonment for a period, for a minimum period of 2 years, or both penalties, both fine up to 5,000 euros and imprisonment for a minimum period of 2 years. The most important aspect here is that the assessment and collection of taxes laws were amended so that in the event where a person fraudulently submitted inaccurate declaration or accounts or information, or in the event that the person who collaborates, assists, advises in submitting such information is a legal person, is a company, then the executive director, the members of the board of directors, and any other officer which has duties relating to the financial control of the legal person, or any person who appears to be acting under such capacity, are deemed to participate in the commission of an offense and are guilty of such an offense. So, both the company and the director can be found guilty for the offense of submitting inaccurate accounts, inaccurate declaration, and inaccurate information. So, my advice here is that as a company director, if you signed any declaration or accounts, or if you are called to provide any kind of information to the authorities, please be sure that this kind of information is not false, is not misleading, is not inaccurate. Check the information you provide. It's very important for your protection. It's very, very important for your protection. Check any information you provide to the tax authorities. Now, many people raise the question if a nominee director can somehow be protected from the unearned revenues claims. In order to examine this, we need to understand which companies can be considered as Cyprus tax residents. According to the Article 2G of the Income Tax Law of 2002, resident in the Republic, when applies to a company, means a company whose management and control is exercised in the Republic. The problem here is that there is no specific definition, either in the income tax law or in any other Cyprus law, as to what constitutes management and control. According to the case law, because we can rely on the case law, a company resides for the purposes of income tax where its real business is carried on, and the real business is carried on where the central management and control actually abides. In addition, as it was mentioned in the Bullock case, the company may be properly found to be reside in a country where it really does business. That is to say, where the controlling power and the authority, which according to the ordinary constitution of a limited liability company is vested in its board of directors, and the exercise of that power and authority is to some substantial degree to be found. Therefore, one substantial criterion that the tax authorities use for defining the management and control is the place where the board of directors meets and takes decisions. In order to facilitate this, the tax authorities suggest that all directors, or at least the majority of directors, should be Cyprus residents. Hence, the tax authorities during the issuance of the tax residency certificate require the submission of an application, which must be signed, of course, by the company director. And by signing this application, the company director declares 4 main points. Firstly, that the majority of the board of directors meetings take place in Cyprus, that the board of directors exercises control and makes key management and commercial decisions necessary for the company's operations and general policies. Third, that the minutes of the board of directors are prepared and kept in Cyprus. And lastly, that the majority of the board of directors are tax residents in Cyprus. In addition to the above, the company director, along with his signature, because as we said, the director will sign the application. So along with his signature, the company director has to complete his TIC number, the tax identification code, as proof of his Cyprus residency. So the tax authorities will know that the company director or the company director presenting the board of directors is a Cyprus tax resident. We will now have a look at the VAT Act of 2002. VAT legislation imposes a strict liability to the company directors. Specifically, sections 53 and 54 of the Cyprus VAT legislation state that if a legal entity is guilty of any of the offences referred to in the law, responsibility of such an offence, except from the legal entity, is also with all the members of the board of directors and the general manager or the director or the chief executive director of the company. So if the company is found guilty of any of the offence referred to the VAT Act, the company director, the members of the board of directors, the chief executive, general manager can be also found liable for committing such offences. Moreover, under section 48 of the VAT law, whenever a criminal offence is committed by a legal person, by the company, then the company as well as its directors, managing directors, and managing officers bear the liability. So it's clear that the company director is also liable along with the company. It's important to mention here that there is no need to prove criminal intention or criminal mind to commit VAT wrongdoing in order to substantiate the criminal offense. Directors bear personal criminal liability, and I underline this, personal criminal liability for their company's failure to comply with the VAT law. Therefore, the courts may impose penalties or even an imprisonment sentence on director whose company has failed to settle the VAT and has failed to submit the VAT returns. And the reason for that is that VAT law is of public interest and concern, and non-payment of VAT is equal to steal from the government's treasury. That's why VAT legislation imposes strict liability on companies' directors. Now, under Section 55 of VAT legislation, apart from criminal liability, which may lead to a fine and or imprisonment of at least 2 years, company directors also bear civil liability for any tax that is payable by the company to the state. Now, let's move on to the civil offences law. Under the civil offences law, a director may be found liable for the tortious acts of his company where he has authorized, for example, by his signature, or directed or procured the tortious act, and such director need not have known that the act was tortious. Therefore, ignorance is not a defense. This is very important to keep in mind. You cannot provide as a defense that you weren't aware of the law. Just to know, there is a general principle in Cyprus law according to which ignorance does not constitute a defense. So as a company director, you are obliged to know your duties and your obligations imposed by the law. Always remember that ignorance is not a defense. Now, talking about the listed companies, the Cyprus Securities and Exchange Law contains relevant provisions for directors in listed companies. Section 189 of the Cyprus Securities and Stock Exchange Law state that anyone who, in the course of providing information for any of the purposes of this law or the stock exchange regulations, makes a statement which is false, misleading, or fraudulent with respect to a material element of it or conceals anything material, commits an offense. It is also important to note that under Cyprus law, as I have already mentioned, it is possible for both the company and the director to be convicted. So, under Article 190 subsection 2 of the Stock Exchange Law, persons who are, according to the provisions of the preceding subsection, incur criminal liability for offences committed by a legal person, by the company, are jointly and severally liable with the legal person for any damage caused to third parties as a result of their action or omission which constitutes the offense. So both the company and the company director are jointly and severally liable for any offense and for any damage caused to third parties. Lastly, directors can be found criminally liable under the provisions of the AntiMoney Laundering law of 2007. Administrative sanctions are also applicable. Um, Directors should apply adequate and appropriate systems in relation to client identification and due diligence, record keeping, and all the other matters arising out of the AML law, the anti-money laundering legislation. So, under the anti-money laundering legislation, a director who knows or suspects that a person is engaged in laundering or in financing terrorism offenses, and the information on which that knowledge or suspicion is based on comes to his attention in the course of his trade, his profession, his business or employment, must immediately disclose such information to MOCAS. MOCAS is the unit in Cyprus for combating money laundering and terrorist financing. So the company directors who have suspicions of such transactions or activities must immediately disclose this information to MOCAS. Now let's check the SISEC directive of 2008, which provides that the director must ensure that all obligations under the law and directive are complied with. The directive also provides examples of suspicious transactions and suspicious activities related to money laundering and terrorist financing, and therefore directors should be able to recognize if a transaction might raise money laundering suspicions. Examples of such suspicious transactions include unnecessarily complex transaction. What that means, when four parties are doing the work of two. So if something can be done by two persons and more than two persons are involved to this activity, this can raise suspicions. Also, the transactions or the size of the transactions do not comply with the usual practice and business activity of the client. This can also raise suspicions for money laundering or for financing terrorism. A third example is the settlement of any transaction in cash, and especially in large amount. Because what is the reason of transacting large amount in cash and not doing that through your bank account? These raise serious suspicions, very serious suspicions. And the last example, any transaction, the nature, size, or frequency appears to be unusual. As far as you understand, many laws impose liability on company director, and company director can be personally prosecuted and can be personally liable and guilty for breaches or offenses of their companies. I would also like to mention here that many statutes and many laws have included in their body the following section in order to prevent the company directors to hide behind the corporate veil and the privilege of limited liability. So, where an offense committed by body corporate, by the company, is proved to have committed with the consent or connivance of, or to be attributable to any negligence on the part of any director, manager, secretary, or other similar officer of the company, or any person who is purporting to act in such capacity, that person, as well as the company, shall be guilty of that offense and shall be liable to be proceeded against and be punished accordingly. Now we will move on in the second part of our webinar, which is the extent of director's liability. According to section 194 subsection 1 of the company's law, the director's liability in a company may be unlimited if this is provided in the memorandum of the company. However, the truth is that this rarely occurs. There is no memorandum stating that the liability is unlimited. In order for this to be the case, the directors and any managers of the company and the member who proposes a person for election or appointment must add to that proposal a specific statement that the liability of the person will be unlimited, and before the person accepts the office, accepts the position, notice in writing that his liability will be unlimited must be given to him. Many raise the question if there is any way for the company director to become exempt of liability, so not to be liable. As I have already mentioned, under section 197 of the Companies Act, it is not possible to grant a general exception in advance to directors in respect of liability to the company. However, this does not mean that the director is deprived of any possibility of exception or is deprived of the right to be indemnified in respect of anything carried out by him. The truth is that the company may indemnify directors against the costs incurred in legal proceedings, whether civil or criminal, in which judgment is given in the director's favor, and also the court may grant relief under section 383 of the company's law, and the court is entitled to relieve directors, has such a power to relieve directors wholly or partly from liability if in any proceedings for negligence, default, breach of duty, or breach of trust, it appears to the court that the director has acted honestly and reasonably. This is the criterion, honestly and reasonably. Pursuant to section 383 subsection 2, the director is able to apply to the court for relief if he apprehends that an action for breach of duty or breach of trust or breach of obligation, negligence, or default will be taken against him, and in such case the court may grant him a relief. It is notable that it is not enough for the directors to have acted honestly and reasonably. Of course, this is the main criterion, but the company director must additionally prove that he ought to be justly excused. Taking all the above under consideration, the appointment of a nominee director or a legal person providing nominee services, because a company can also provide a nominee services. So such an appointment does not refute any civil or criminal liability. Any prosecution against a nominee director cannot be suspended for the mere reason that the director of the company is involved as a nominee director. For that reason, nominee directors should take preventive measures to avoid any potential liability arising out of his directorship. And example of these preventive measures is the liability insurance, for which we will talk in our next webinar on 7th of February. And those of you who can attend this webinar, please do so, because it's very useful to know what you can do to protect yourself as a company director. And also the webinar, we will examine the duties of the directors, the categories of the directors, shadow, de facto, nominee, etc. And we'll analyze further the liability insurance. Just to give you an idea, liability insurance is an insurance payable to the company director, and of course to the company's officers, but now we're talking about directors, so I focus in company's directors. It's an insurance payable to them as indemnification for any loss or for any defense costs that the director suffered as a result of a legal action brought against him for alleged wrongful acts in their capacity as director. We will analyze this topic in our next webinar, and you are very welcome to attend this webinar and get as much information as possible for the insurance liability and what you can do as a company director to protect yourself from any potential actions against you. So to come back to the nominee directors, as we said, the nominee directors must take preventive measures to avoid any potential liability and protect themselves. So in case a nominee director has lost all contact with the beneficial owner of the company, and the beneficial owner of the company is not coming back, is not answering to any emails, he must immediately resign from his position as a company director, because in the registrar's registry, the name of the nominee director is mentioned as the company director, so the beneficial owner has nothing to be afraid of, and the company director is the one who must be protected for this scenario. So he must immediately resign from his position. He must immediately inform all the relevant authorities from a loss of contact. The authorities, for example, the registrar of companies, the tax department, the VAT authorities, the banks, and any other authority. He must protect himself by notifying all the relevant authorities that he lost contact with the beneficial owner of the company. Therefore, nominee director must know and understand their duties, obligations, and liabilities under all applicable laws, ensure that the company complies with all its legal obligations, monitor and be aware of the company's activities and transactions. And at this stage, I would like to inform you that Eltoma Corporate Services do provide nominee services. However, we only provide nominee services if we provide a full service for a company, including bookkeeping, secretarial, and tax reporting. In that way, Eltoma Corporate Services can effectively protect its nominees for any potential liability may arise in the future due to the company's fraudulent act or in compliance with the applicable laws. Well, this is the end of our webinar. I hope that you take all the required information regarding the company's director's liability. Now, some words about our company, about the Eltoma Corporate Services. Since 2004, Eltoma Corporate Services has maintained a competitive position in the corporate market. For over 10 years, our clients have enjoyed the range of products and services we offer, which have given them opportunities for solving international tax planning issues, asset protection, as well as the promotion of goods and services for international markets. Eltoma Corporate Services offers solutions of varying complexities for company registration, legal and tax assistance, to establishing and maintaining composite holding structures. We have offices locations in Cyprus, Singapore, Russia, Ukraine, and Hong Kong. Eltoma Corporate Services aim to provide our client base with a personal, cost-effective, and efficient service. Our client base has substantially and internationally grown over the years, yet we still retain our core values of professionalism, cost efficiency, and personal services. Our corporate services include company incorporation and maintenance, banking and finance, bookkeeping and accounting services, tax planning, IT and web services, software for business, web and marketing services, legal advices, immigration services, license and permits, work permits, visas, etc. The Eltoma Group expanded to deliver custom recruitment services to support employers within the Cyprus market to select the best person in the correct position. Moreover, Eltoma can assist you in investing in Cyprus. So that's all. Thank you very much for your kind attention. Below, you can see our contact details. Please do not hesitate to contact me for any inquiries or clarifications or any further information you may need. Please feel free to contact me to my email dora.leonidou@eltomaglobal.com. Once again, thank you for your attention. I hope to see you again in my next webinar on director's duties and liability insurance. Will be scheduled in 7th of February 2008. Thank you and have a nice day ahead.